Hi, everybody. I just thought that I would give another example of the kind of thing I'm talking about here. And honestly, I could do this all day, which is rather sad. But again, being on my desk, so this idea, the basic idea here is that we have got to treat everybody equally, that we cannot dispense justice in a preferential way in any respect. This is a very basic kind of thing. And if you're looking for the catch, there is none. That is really what this is about. So if one way that we really should not treat people special is by prioritizing their motions to be heard. Now, I have to tell you, in my entire career, this has never been something that's ever been an issue. Motions are heard in order. They're just heard in order. And frankly, somebody files a motion and, it's set for a hearing and heard. Now, I practiced in federal court. The volume's much lower. I get that, family court, isn't like that. And there's not as much due process in court time for everybody, and you got to do your best and just do your best. I get that, but we should not be letting people skip in line. We should not have a circumstance where, here we go, we have a hearing where we're going to hear 14 motions that have been pending, dating back to, late 2020. I don't really know or remember anymore what these are about. I'm sure Katie will tell me, but they were certainly important at one point in time. I would guess, and I'm looking at one right here, that justice delayed is justice denied, quite literally, right? Here's an example. So if it were up to me, none of this would be resolved in court, but it's not up to me. Ultimately, the other side has to agree to kind of negotiate these things. And whatever. So, it's an issue regarding where our oldest daughter goes to school. A motion was filed by our side to have this issue addressed by the judge on January 14th, 2021. We're going to hear that issue, I guess, Monday, maybe. So she started school 4 months ago. Okay. Now, I don't have to tell you that that's a circumstance where you might as well just, that motion has already been effectively denied, right? Okay. So when we talk about how do people that work at the court, how are they in a position themselves, even if not the judge, to basically act as the judge? And that's a great example, right? So let's just suppose that you're in charge of the court's docket. Okay, let's just suppose your name is Alice Keys. And let's just suppose that, you are in the business of granting preferential treatment to certain people for whatever reason. And that me and Katie are not one of them, or any of the other dozens upon dozens of lawyers that don't have whatever kind of special access card you need down there to get this kind of special checkout line for justice. Maybe you don't like me or whatever, I don't know. And maybe you just want to kill this motion. You don't, you want to deny it. The judge is never going to have an opportunity to consider it. You're absolutely in a position to do that by, as the scheduler, scheduling it for a time where the opportunity to get relief or the relevance of the motion has expired. And that motion that I just mentioned to you would be an example. Let's be clear about what this is about. It is about this idea that is really important, that all people are created equal, that there ought not be any preference given to anybody, lawyers or litigants, in connection with a court. I'm not saying that I should get special treatment at all. I'm specifically, endeavoring to stand up respectfully and say this is nonsense, and no one should get special treatment. It shouldn't matter who your lawyer is. It should not matter if you have a lawyer. And under the law, it doesn't. And yet in that forum, in the Kenton Family Court, it very clearly does. It's a matter of empirical reality. I could sit here all day and give examples of that. And we all know that the kind of example that I just discussed should never happen. We know ipso facto in that circumstance that our system of justice has failed us. Why? because we all have the legal right to be heard in accordance with the law. And if we are heard, quote unquote, far after the period of time within which the court can grant relief on the issue about which we are seeking the court's intervention, that is really, we haven't been heard at all. That is what we're trying to, redress here. So that's something that I wanted to talk about. I wanted to talk about another issue that just recently came up real quick as well, by way of another example. There's, again, this concept of the law, okay, is an important one, and we should not we should not lose sight of that. It should not surprise anybody that it is not okay to simply walk into court and just say horrible things about people willy-nilly. Believe you me, that there are professional rules of conduct which govern our conduct as lawyers, one of which is we must have a factual basis to say things. We can all imagine what a horrible thing it would be, especially in family court, to walk into court and just because you don't like somebody or you happen to be upset with somebody for whatever reason, to allege the worst possible things that you could ever allege about that person with absolutely no basis to do that whatsoever. To use an example of this, we can all agree that, let's just say, hypothetically, if Ms. Lawrence was in the process of getting divorced, and hypothetically, if Stephanie Dietz represented, coincidentally, her ex-husband, and, and hypothetically, if, as mature adult parents committed to, co-parenting the right way in the best interest of their kids, they were in a position, if they spoke, to work things out at a high level such that there wasn't tremendous animosity and it'd be great for the kids moving forward. That, of course, doesn't generate fees, people. Peace does not generate fees. Understand this. It's my forever objection to the legal profession and the reason I have my own law firm here. War, conflict generates the need for lawyers and thereby the need for revenue streams. And, if it was not kind of consistent with the idea of making money for Ms. Dietz in that circumstance to allow that peaceable, kid-friendly, resolution to play out, and she just walked into court hypothetically and said, well, Ben Dusing, abuses children, hypothetically, with no basis whatsoever, simply to, throw herself in front of a solution otherwise very much in the best interest of Katie, Ms. Dietz's own client for that matter, and for certain their kids. I mean, not only is that morally reprehensible, the idea of prioritizing a lawyer's revenue, profit, above their legal, moral duty to serve the interests of their clients, things which are often in conflict. Not only is it that, but it is also a violation of the professional rules if in fact there is absolutely no basis in fact to say that. These rules and this concept of law is just an important one in our courts, and I just had this on my desk, so I thought I would mention it. Look, let's be very clear. I have no idea how I found myself in the middle of this mess, but I do, and for better or worse, bravely or stupidly or whatever, given what I've seen, let's stop this, and we need to get this right, not just for me and my family and my kids, and not just for Katie and her family and her kids, and not just for all the lawyers out there representing clients and their kids who, I know firsthand are thinking the very same things that I am saying. These things need to be said, and they need to be shared, and we need to fix this problem. I am not interested in punitive justice. I don't care. We need to fix a court system and make it a court system and make it the rule of law. And if I'm that guy, I'm that guy, and it makes sense that I would be that guy. That's what we're doing. Thanks.